This blog is about obtaining information about the other party's superannuation. Superannuation has been a part of family law for a long time. You can now split superannuation in Australia in all states and territories, except, of course, in Western Australia in relation to de facto couples. And hopefully that position will change soon. Even if you're not splitting superannuation, you have to have some idea of the value of each of the parties' superannuation. So it's important to be able to obtain an accurate value of the other party's superannuation. So in Australia, each party's supposed to provide a full and frank disclosure of their assets and liabilities. And what that means is that upon request, each party should provide to the other a statement of the current balance of their superannuation. The problem is that from time to time, one of the parties won't comply with their obligation to provide a full and frank disclosure. And in fact, I see that all too often, especially in the early stages, and especially before the other parties obtain legal advice. You tend to find that once the other parties obtain legal advice, they're more forthcoming in providing the information such as their superannuations. What you're supposed to do is provide the other party with a statement of your superannuation as soon as possible. Reasons why the other party won't do that? There's many reasons for that. One, they're just being plainly unreasonable. One, they don't understand their legal obligations. One, they're just trying to be difficult, and they don't want to split their superannuation. So there's many reasons. And like I said, it's often more in the early stages. Starting point, the first option potentially is to get a lawyer to write the other party a letter. But again, quite regularly, you see it, which is unfortunate, is that the other party might ignore that letter. So the next course of action might be to then commence court proceedings and bring an application that they provide, and disclose their current superannuation statement. That application would be successful. Two downsides, I suppose, to bringing that application. One is that you're probably going to incur significant legal costs, and although you'll be successful, you may or may not recover some of those legal costs from the other party, because the starting point in family law is that each of the parties pay their own legal costs. The second downside is that although that application will be successful, there will be some delay in between the filing of the application and the court hearing. So it's not an ideal solution. The better option, perhaps, and the low-cost option, is to complete what's called a Form 6 request for information in relation to superannuation. That form's available from the Family Court website, and it's a simple matter of completing the details in the form and then submitting it to the trustee of the other party's superannuation fund. Upon receipt of the request for information, the superannuation fund is obligated to then provide the requesting spouse with the information in relation to the superannuation, including a valuation of the members' superannuation benefits. So there will be usually a small fee payable. It varies from fund to fund, obviously, and you can find out what that fee is by looking usually on the superannuation fund's website or by giving them a call. The usual time for compliance for the superannuation fund is 28 days. So it's a low cost and efficient and timely way to obtain information about the other party's superannuation. The only downside is that you have to have some idea of the superannuation fund that the other party is a member of, because you actually have to submit that Form 6 to the particular superannuation fund, because there are so many superannuation funds in Australia, you can't randomly send out Form 6s to each of those funds. You have to have an idea of which superannuation fund the other party is a member of. So that's really the only sticking point to using a Form 6. Sometimes on occasions a client will come in and they won't have any idea which superannuation fund the other party is a member of. That creates real difficulties if the other party's being difficult. And then of course the only option potentially is to bring a court application. Knowing which fund it is, it's a simple matter of completing and submitting the Form 6. The Family Court website also has a kit on how to complete and submit the forms, and it's a very simple, less costly and more efficient way to obtain information about the other party's superannuation.